Hello guys, welcome to LawPutra YouTube channel. I am Bhavna here. Today we are going to discussing about the topic the doctrine of pith and substance in Indian Constitution. Okay, let's say what is a doctrine of pith and substance, what are its ingredients and its related landmark judgments. Okay, let's get into the topic. Now let's say what is doctrine of pith and substance, where do we use it and why do we use it. Okay, before going, as we know that the Constitution of India has divided the extent of legislative power between central and the states by the way of 7th schedule. As we know, under 7th schedule, the legislative power is divided into three lists: union list, state list and concurrent list under 7th schedule. Okay, this is we all know that union list, state list and concurrent list comes under 7th schedule. Okay, the 7th schedule specifies subject matters and divide the powers. Okay, 7th schedule specifies subject matters and divides the power to make laws between center and the state. It helps to divide and to make power between central and the state. Okay, as we know that central has separate power and state has separate powers, both didn't collide. Here gets the topic, what if both collides or what if both interprets each other. Here comes the doctrine of pith and substance. Okay, let's see what is doctrine of pith and substance here. This doctrine comes into action when there is a conflict between the different subjects in different lists. Okay, this doctrine comes into action where there is a conflict between different subjects of different lists. Suppose there is an interpretation of list 1 and list 2 of Constitution of India. The doctrine of pith and substance is applicable. Okay, as we all now discussing the doctrine of pith and substance, let's see what is actual meaning of doctrine of pith and substance. Here the word pith defines a true nature or essence of something. Okay, pith means true nature or essence of something, and substance means the most significant or essential part of something. Okay, pith denotes essence of something and substance denote essential part of something. Okay, are you clear between the both words pith and substance? Okay, this says about the doctrine of pith and substance. To deal with the conflict between two lists, this doctrine is evolved. Okay, to deal the conflict between two lists, as we discussed the central list, state list and concurrent list, if there is a conflict between these lists, then to solve this doctrine is allowed. This doctrine of pith and substance is allowed. Okay, now let's see what is its origin and where it came from. Okay, actually it came from this doctrine lies in Canada. Okay, the first it is used in Canada, introduced in the case named Cushing versus Dupuy. Okay, remember the name Cushing versus Dupuy in the year 1880, and come in India it was evolved and it's supported by Article 246 and 7th schedule. This article is this doctrine, the doctrine of pith and substance, is supported by Article 246. Also remember, as we are saying, this doctrine is supported by Article 246 and 7th schedule, but this is never actually mentioned by the name, the doctrine of pith and substance, in the Constitution, but it is supported by Article 246 and 7th schedule. Okay, in India this doctrine is evolved, it is seen in the case firstly in State of Bombay versus FN Balsara. Okay, State of Bombay versus SN Balsara, remember the case, and let's discuss these cases when we discuss about the case laws. This doctrine states that within their respective spheres, okay, within their respective spheres, that the state and the union legislatures are made supreme, that state and the union legislatures are made supreme. They should not encroach upon the sphere democrated for others, that they should not encroach spheres democrated for others. One, the state should not encroach upon the union legislature and union legislature should not encroach upon state legislature. What if there is some situation, what if they encroach each other, then this doctrine is applicable. If one among the state and center does encroach upon the sphere of others, the court applies this doctrine. Okay, if one among the state and the center does encroach upon the sphere of others, then this doctrine is applicable by the courts. Okay, now let's see what are the ingredients of this doctrine. Okay, this doctrine is applied when the subject matter of list 1 of 7 schedule is in conflict with the subject matter of list 2. Okay, as we said, this doctrine is applicable when there is a subject matter is in conflict of list 1 in 7 schedule and list 2 of 7 schedule. Okay, and second point, this doctrine examines the true nature and the substance of legislature. Okay, true nature and substance of legislature in order to determine which list belongs to which. Okay, which list belongs to it. Okay, and third point, it takes into consideration whether the state has the power to make the law that encroaches on a subject matter from another list. Okay, it takes into consideration whether the state has the power to make a law that encroaches a subject matter from another list. Okay, it is first applicable and upheld in the case by the Supreme Court in F and Balsara case, as this was discussed before point, and this doctrine is employed in such cases to resolve the inconsistency between laws made by the center and the state legislature. Okay, these are the ingredients, and let's discuss the case laws. The landmark judgments in the doctrine of pith and substance are State of Bombay versus F.N. Balsara and Prafulla Kumar Mukherjee versus Bank of Kulana. Okay, Prafulla Kumar Mukherjee versus Bank of Kulana. Let's discuss case number 1, the State of Bombay versus F.N. Balsara. Here, in the case of State of Bombay versus F.N. Balsara, the Bombay Prohibition Act was challenged on the ground that it accidentally encroached upon the import and export of liquor across the customs frontier. Okay, it was challenged upon the ground that it accidentally encroached upon the import and export of liquor across the custom frontier. Okay, a center subject. Okay, here liquor export and import of liquor comes under a state, under a central subject, where a Bombay Prohibition Act comes under the state subject. Okay, here the court decided that the court, while upholding the impunged legislature, declared that the act was in pith and substance. Remember, this doctrine is applicable. Impunged declared that the act was in pith and substance of a state subject. Okay, of a state subject, even though it incidentally encroached upon the central subject. It accidentally encroached upon the central subject, where this doctrine of pith and substance is applicable. This is about the State of Bombay versus F.N. Balsara case. Now let's see what is about Prafulla Kumar Mukherjee versus State of Kulana. Okay, in this case, the Bengal Money Lenders Act 1946, enacted by the state legislature. Here, the Bengal Money Lenders Act comes under state subject, was challenged with the contention that the parts of legislation dealt with promissory note. Here, promissory notes comes under central subject. Bengal Money Lenders Act is a state subject and promissory note is a central subject, where there is a conflict between these 2 points, Bengal Money Lenders Act and the promissory note. Here, the Privy Council, while upholding the validity of the impunged legislature, stated that Bengal Money Lenders Act was in pith and substance. Okay, this doctrine of pith and substance is applicable, and was in pith and substance a law relating to money lenders and money lending as a subject, even though incidentally trenches upon the promissory note as central subject. Okay, here the doctrine of pith and substance is applicable and the conflict is resolved. This is about the case laws and the landmark judgments in relating to doctrine of pith and substance. I hope you are clear with the points. If you have any doubts, please leave it in the comment section. If you like the video, please do like, share, comment and subscribe to LawPutra YouTube channel. Thank you.